a more in-depth look at how Board of Trustees hearings are conducted and how you might be able to support a young person in those situations. It's amazing how many calls we get where people aren't aware that they're able to take support people, or it doesn't necessarily need to be a lawyer, but just a trusted adult or a trusted professional in their life to support them in the board hearing to try and get the best possible outcome and prevent them from being removed from school. Just a few housekeeping matters as well. We are required to report to the Ministry of Justice on the education we deliver. So if people are attending on one computer but there are multiple people, if people would be happy to type their name into the chat box just so we've got a record of individual participants, that would be fantastic. Secondly, at the end of the webinar we'll be distributing a SurveyMonkey survey just about how useful you found the webinar, and we'd be very appreciative if you would be able to complete that and send it back to us. It enables us to make sure that we're actually delivering webinars that are helpful for you and what we can do in the future. So I'll probably just get started now. We're running a little bit late. I know we don't have that many people participating, but hopefully people want to watch this at a later date. So you will recall that some of our earlier webinars talked generally about the right to education and how schools can carry out discipline under Section 14 of the Education Act. You'll remember that there are quite strict limitations on schools. So there's strict criteria and thresholds to be met before a school can actually justify Section 14 discipline of a student to remove a student from school. So you'll remember last time we talked a little bit about the international law that governs the right to education, in particular the United Nations Convention on the Rights of the Child. Articles 28 and 29 are the key articles that you might want to cite if you're ever having to stick up for a young person in this context, and they're sort of asking you what law you might be relying on in terms of international law. Articles 28 and 29 state that young people have the right to a good quality education that develops their potential to the fullest. They should also be treated with respect. So discipline in school should not be degrading or subject the young person to cruel or unusual punishment. And that sort of works in conjunction with particular rights under the Bill of Rights Act. So the Bill of Rights Act notes that no person shall be subjected to cruel and unusual degrading treatment. So in addition to the rights under the UNCROC Convention, you've also got general life liberty rights under the Bill of Rights Act. What it is important to bear in mind is that New Zealand is in a system where international law is not directly incorporated into our domestic legislation or statutes. So the Education Act has got no explicit recognition of the United Nations Convention on the Rights of the Child. New Zealand has ratified the convention, so it is binding on the state and all bodies carrying out state functions, such as schools carrying out education. But what it means is there's no particular section of the Education Act which you can point to which says, okay, the United Nations Convention on the Rights of the Child has been breached by this particular section of the Education Act. Same thing applies with the Bill of Rights Act. It's in legislation, but it's not what we call protected or entrenched legislation. So you're probably aware in America that their constitutional rights, are very strongly entrenched and protected. That's not the case in New Zealand. The Bill of Rights Act has got the same authority or standing as any other piece of legislation. So it's not entrenched or more powerful than other pieces of law. What is provided for within the Bill of Rights Act is a reasonable limit on protection of those rights where needed in a free and democratic society. So, for instance, the government might enact particular laws that potentially might inhibit your ability and freedom of association, but actually it's required in a free and democratic society. Even though you might be supporting a young person and quoting bits of law, it's important to remember that there's no clear recognition of the international law and our domestic law, although it still is binding on schools, so they still need to make sure they carry out their actions consistently with it, and also that the Bill of Rights is not entrenched or protected legislation. So you can refer to it, but you can't say the Bill of Rights trumps all the other rights that the schools have to carry out their daily administration of the school under the Education Act. So, getting on to powers of schools and teachers, you remember I talked a little bit about this in one of the earlier webinars. Under Section 75 of the Education Act, a school board has complete discretion to control the management of the school as it thinks fit. Now, that's a really broad and wide-ranging discretion. Essentially, it's just saying that they've been given carte blanche, full discretion to enact school rules and make decisions as they think fit. Of course, their powers are limited by other procedural rights and protections in the Education Act, but on the face of it, that's a really broad power. And when you think about how school boards are generally constituted, you'll remember I talked a little bit about this in earlier webinars, but school boards are constituted from members of the local community. Very often that can include parents of particular students in the school or other people that are interested in administration of the school that live in the community. Whilst there are great benefits with this, and I think when the system was initially introduced, there was an understanding that this would devolve a lot of bureaucratic administration from the Ministry of Education to local communities, taking charge of their own education in their own community. There are some issues that arise with it. Firstly, that can mean that your school board is constituted of members which don't have professional qualifications in education law or have not trained to understand education law, so they may not completely understand all their obligations to follow a due process and natural justice. You'll remember I talked in one of the earlier webinars on discipline under Section 14. There are really strong obligations on schools when carrying out procedures under Section 14 of the Education Act to ensure it's consistent with natural justice and complies with the procedures set out in the Education Act. But what can happen is if school board members don't have any training and are plonked on a school board, and very often, they might know the student that's facing disciplinary proceedings. For instance, it's a child with special needs and they know that little Johnny has hit their son Michael the other day. They're probably going to have a slight bit of bias coming to the decision making when it comes to deciding whether or not that student should remain in school. And there may be some issues around whether the process is entirely fair, impartial and unbiased. On the flip side as well, the principals, because they have so much knowledge with the day-to-day running of the school and because board members are so removed from the day-to-day operations of the school, very often a board can rely very heavily on what a principal has to say in terms of an authoritative voice as to whether or not a student does belong in the school. So you'll see there, Section 76, a principal has complete discretion to manage the school as the principal thinks fit. What this can mean is that very often a principal, can have the final say on whether or not a student then has to go through the suspension process and possibly face final and permanent removal from the school. That wide discretion given to principals means that, sometimes the principal might invoke procedures that aren't strictly in compliance with Section 14 of the Education Act. So remember I talked a little bit about this before, but essentially Section 14 of the Education Act sets out the only time that the school should be able to and legally remove a student for disciplinary reasons. But certainly we're hearing a lot more through our advice line. Principals invoking procedures that aren't compliant with Section 14 that result in removal of the student from school and may be subject to arbitrary and unfair conditions or means to even participate in the curriculum. So I'm not sure how many of you saw it, but probably over a year and a half ago, there was a news story about a particular school in Northland where a principal was using his discretion, arguably under Section 76, and students whose parents had not paid donations to the school were excluded from class and locked in a separate room. Now, you'll remember in our first webinar we talked about the right to education and the right to the basic participation in the mainstream curriculum. Obviously, there's some real issues around a principal doing that. Obviously, they have discretion to do it, but it probably isn't consistent with the rights set out in Section 3 because all students under that section have a right to achieve a reasonable standard of education to enable them to function adequately in the future. So basic numeracy, basic literacy. So although the principal's got discretion, it's probably tempered against those other rights, such as those in Section 3, the UNCOC rights, the Bill of Rights rights. Obviously, they can't subject anyone to cruel and unusual treatment, like stringing them up or beating them or anything like that, particularly in light of changes to corporal punishment anyway. So yeah, just kind of to keep in mind that Section 75 and Section 76 are really powerful. Principals and boards have a lot of power, and a lot of times we hear through reports in our advice line that they don't have a lot of knowledge about the ins and outs of how a process should be carried out consistently with Section 14, or when they can use processes which aren't compliant with Section 14. I mean, the strict answer is that you should never invoke a process removing a student unless it's compliant with Section 14 and it meets the really strict threshold and criteria of being serious enough under Section 14. But I mean, I do hear about other initiatives like restorative justice initiatives in schools which are informal, which aren't necessarily Section 14 compliant, but can produce really good outcomes for young people in addressing underlying issues and returning them back to school, rather than just disciplining them and then underlying issues still causing ongoing issues. So I'm not going to say it's completely wrong, but I'm just going to say if you're ever supporting a young person, there's a couple of factors to bear in mind. And the significance of the power of the board and the principal means that it's also about treading really carefully if you're supporting a young person, because these powers mean that very often that decision's final. If they make that decision that a student needs to be removed from the school, it can effectively mean the end of that student's schooling career at that school and difficulty getting into another school. So trying to maintain that relationship and understanding the quite strong power that's held in balance is probably going to be helpful if you're advocating for a young person. So yes, the school board can make any rules necessary for, the control and management of the school under Section 72. So the significance of this is potentially a school might make a zero tolerance policy for drugs. They might say if you ever are caught with drugs, if you ever are caught with drugs, that you must immediately proceed to suspension. Just because the school rules say that doesn't mean it's consistent with the Ministry of Education guidelines and indeed the rights under the Education Act. And indeed that would be open to challenge because each circumstance has to be evaluated on its individual facts. You'll remember from the last webinar in Section 14 that you can't just automatically say school rule says this, therefore they must be excluded. You need to go through a proper analysis and a fair and due process. So just something to bear in mind when you're advocating for a young person. There are limits on the school's powers. So except to the extent that any enactment of the General Law of New Zealand provides otherwise. So obviously all this discretion is given to boards and principals under Sections 72, 75 and 76 to do as they like, but that must be consistent with any other law of New Zealand, for instance the Bill of Rights Act or otherwise. Traditionally, there was a view that students were still under the jurisdiction and disciplinary measures of the school if they were within school grounds or they were out on a school trip in school uniform or within line of sight from the school. So if they were walking home from school and you still saw them in their school uniform, there's a strong argument that the school still has a legitimate interest in what they're doing. So if they're doing drugs or doing something inappropriate and they're in school uniform and it's, just outside of the school grounds, arguably the school could still say, look, we've got jurisdiction to take disciplinary action against the student. Things are sort of changing a little bit. You'll remember I talked a little bit about this in our cyberbullying webinar, and the fact that jurisdiction is now really wide-reaching because of the reach of technology. We'll talk a little bit more about the limits on that in our search and seizure webinar, but essentially if a student's engaging in cyberbullying of another student and it affects the school environment, potentially the school's jurisdiction could extend to posts that are made at 12 a.m. That are on the student's own private computer and not even on school grounds. So it is kind of changing, but traditionally with your traditional types of disobedience or gross misconduct, which we discussed in the earlier webinar, you're going to have to prove that the student, was within the school's jurisdiction. If the school, is alleging that the student did something on the weekend and they were in mufti clothing, they weren't wearing school uniform, and that the school had jurisdiction over it, a bit harder to make out that case, I'd say. And you'd probably, if you're advocating for a young person in that situation, really point that out and point out that school jurisdiction needs to be within appropriate boundaries. So you'll remember I talked again about the right to education under Section 3 and the entitlement to enrolment in free education at a state school for children between the ages of 5 and 19, in particular enrolment in their local in-zone school. There's an obligation on schools as well under the Education Act to provide guidance and counselling to students who are going through a disciplinary process. So if pastoral care is needed, the school specifically has an obligation to provide that during any process under the Education Act. The clear thing that probably needs to be pointed out to a school, if they're just saying this student's troublesome, we don't want them in our class, the right to education means that schools can't choose who they teach. So if the student is in zone and entitled to enrolment under the provisions because they're between the ages of 5 and 19 and they want to attend their local mainstream school, schools do not have the right to bar that student attending. Obviously, there are different considerations that come into play when you've got a student that lives out of zone. So they may need to apply through a ballot system or otherwise, and the school doesn't have a legal obligation to accept them. But if you're in zone and you're seeking enrolment in your local public in-zone school and you're a New Zealand citizen, there's no reason why they should preclude your student from attending. So key things that you kind of want to challenge if there's ever a removal of a student from school is checking that the two main prongs is one, whether it was a procedurally fair process, and secondly, whether it's substantively fair. So for instance, if it was just a child elbowing another child and jostling to get to the canteen and get some food before someone else, I'm not sure that that would meet the strict criteria and substance required to justify removal. And also there's things around procedural fairness. So things like a fair process of investigation and all those sorts of things. So for instance, if the school's heard via 3 hearsay sources, so Mary told Sue that told Michelle, I heard that Mary hit Sue after class one day, there's a question of whether if the school just acts on that and doesn't procedurally investigate properly all the allegations with all the different people and actually act on proper evidence rather than just hearsay evidence, it's a question of whether that was procedurally fair as well, for instance. So Section 13 is your key section when you're advocating for your young person in terms of the options moving forward for the young person if they're facing a Board of Trustees hearing. So remember I talked a little bit about in one of our earlier webinars the fact that once the principal makes that decision and Section 14 kicks in and a suspension is issued, the student must proceed to a Board of Trustees hearing within 7 days or 10 days, for instance, if it's the end of the school term. Section 13 is the key section that is the purpose section that informs discipline under Section 14. So Section 13 sets out that this is to provide a range of responses for different degrees of seriousness. You're supposed to aim to minimise disruption to a student's attendance and facilitate their return to school. So essentially, you don't want to take options that would mean that they're taken out of school for long periods of time or removed. And quite key, and I talked a little bit about this last time, cases are to be dealt with in accordance with natural justice principles, which is a really vague, amorphous concept that informs legal proceedings in general, that, fairness, due process, the idea that you know what, much like a criminal case, you know what the charges are against you, you have a chance to respond, and you're given a chance to put your side of the story before a decision is made, and the decision maker is impartial and hasn't already made up their mind. Very similar sort of policies and ideas that inform the criminal justice process are equally applicable in the case of Board of Trustees hearings, even though we don't tend to view them that way and they're generally conducted far more informally. That is important because it's provided for in the statute. So procedural fairness involves things, and this is all set out in the Ministry of Education guidelines. So if you're interested, you can definitely type into Google Ministry of Education guidelines on stand-down suspensions and exclusions, and this will set out a lot of this in a lot more detail. But essentially, having respect for someone's culture. So examples that spring to mind for us is when we work with children from Pacific Island descent. families, sometimes there is some difficulties around how you want to present your case at a Board of Trustees hearing, because there are particular cultural nuances around challenging authority and how you speak to those in positions of authority. But key in that procedure also is that everyone needs to know what's happening. So a student should never feel blindsided by the board's and principal's allegations. The board needs to ensure that they consider all options. So even if the principal is saying, look, I've taken the serious step of suspending the student and I'm asking you, the board, to consider whether or not the student should be permanently removed, it's important to remember that the board is not synonymous with the principal. The board has an independent function under the Education Act to review and check the principal's decision to make sure it actually meets the strict criteria of Section 14, evaluate all the circumstances, evaluate all the possible options, which do include returning the student to school, possibly, before they make a final decision. And they need to do that in a fair and natural justice manner as well. So giving the student the opportunity to be heard and be supported, considering what the student has to say before they make a final decision. Otherwise, if the board's already gone into the Board of Trustees meeting having made their decision and saying that they agree with the principal, that is definitely not natural justice or due process, because the student was never given the opportunity to have their point of view considered. Substantive reasons. So remember I talked a little bit in our earlier webinar that a principal needs to be satisfied on reasonable grounds of either gross misconduct or continual disobedience or serious harm. A lot more detail of the breakdown of this is contained in our earlier webinars. If you didn't catch them, it's probably worth going back to view that if you want to find out a bit more about it. But essentially Section 14(1)A and 1B set out those grounds. And just remember last time I talked about the fact that it's a two-pronged approach. So not only does the principal need to be satisfied, for instance, it's gross misconduct, and it meets that serious threshold of a one-off reprehensible event, but secondly also that it constitutes a harmful or dangerous example. So if it's a serious one-off event, but it hasn't constituted a harmful or dangerous example, it doesn't meet the criteria under Section 14, and the principal would be hard-pressed to justify that suspension, and the board, performing an independent function, should look at it and say, oh, actually, in this case, we think the principal, we're doing an independent check on what the principal investigated, and we think, actually, it doesn't meet the grounds of Section 14, therefore, the student should be returned to school, just for example. So types of removal, the board only kicks in when a suspension occurs. So prior to that, the principal has, as I said, a lot of wide discretion under Section 76. The principal can stand down the student temporarily, which means removing the student for up to 5 school days consecutively in one term and up to 10 school days in 1 year. So that means that the principal needs to notify the Ministry of Education that they formally stood a student down, and obviously the statute prescribes that you can't exceed the amount of those days. So obviously that's consistent with Section 13 of the Education Act, saying that you need to minimise disruption to education and facilitate return to school. And what we're hearing more and more of is the fact that principals are now resorting to informal stand-downs or cooling periods or timeouts or whatever they want to label it. It's basically not formally going through the stand-down process, providing written confirmation, specifying how the conduct meets the Section 14 criteria, and just simply, sending a student home. It is illegal. It's arguably, if it results in long-term removal from education, it's what we call a Kiwi suspension or an illegal long-term suspension, which can end in permanent removal from school. It's unlawful, and the worst part of it is because it's not gone through this formal process, a student has very limited grounds to challenge it through the formal processes. So if you're ever in the situation where you're supporting a young person and they're being subjected to this informal removal or time out, cooling off, and whatever they want to call it, it may just be a matter of pointing out to the school their legal obligations and that they're only authorised to remove a student if they follow those proper processes set out in the Education Act. And as I said, the suspension is a more serious step. If it's not just a temporary removal from school that will teach the student a lesson, but the principal's saying, look, this is serious enough, it needs to go before the board to decide the student's future at the school, then they are removed from school from up to 7 school days. or up to 10 calendar days if within 7 days of the end of the term. And the day count starts on the first full day out of school. So this will include counting to the Board of Trustees meeting day. Why is this significant? I point this out because if you're ever supporting a young person and they've actually been told that they're suspended, but a hearing isn't held until 2 weeks later, it's illegal and unlawful because it's not complied with the time limits set out in the law, and arguably you should just ask the school to forego going through that process because they don't really have authority to do that if they haven't complied with the time limits. So if the board decides to permanently remove a student, so as I said, the board does have a few options. They can just return the student to school. They can return the student on conditions. So conditions need to be, and when you look through the Ministry of Education guidelines, if you are interested, conditions need to be things that the student can reasonably comply with and are not unreasonable or for unlimited duration. So some of the issues that I sometimes encounter with this is where a school maybe imposes conditions on a student, but they're for unreasonable periods, or they're actually not possible for the student to comply with. One example would be requiring drug testing at $100 a month. The student personally can't comply with that. It's probably dependent on their parents, and so that's not a condition that can be imposed on a student when it's required to be a condition the student can comply with themselves. Other examples include where a school might take informal action and remove a student and then move to formal removal of that student again under stand-down provisions. Effectively, that would breach double jeopardy concepts. So you're probably aware in the criminal context, you can never be punished for the same crime twice. Same thing if you think about natural justice and fairness and all of those things under Section 13 that inform any disciplinary process, a school should never do anything which breaches the requirements of natural justice. So if a board says, okay, we've done our independent check, we agree with the principal, this is serious enough to warrant meeting the threshold for gross misconduct or continual disobedience, for instance, and we think that the student needs to be permanently removed, now, this is a really big decision and it should really not be taken lightly. So if you're ever in the position where you're advocating for a young person, you probably want to point out Section 13 and the fact that retention in education is vital where possible, and that the board should consider all options, and this should be a final resort, not just one of the options that they consider. Where a child is under 16, they are excluded. There will be a need for them to be enrolled at another school because obviously between the ages of 6 and 16, if you're not enrolled in school, your parents can face truancy prosecution. The principal within 10 days must facilitate that enrolment in another school, and the Ministry of Education also must assist. Where there's reluctance on a part of a school to accept a student, the Ministry of Education has powers under Section 16 of the Education Act to order a direction of enrolment at a particular school. So essentially telling a school they must accept enrolment of this student. What we're hearing a lot of is students who may be excluded and face real difficulties getting into other schools because other schools have looked at their pastoral record and said, well, we don't want to enrol this student. And at times, the Ministry of Education will step in and utilise their Section 16 direction. We get some reports from people in the sector and obviously through our advice line that the Ministry of Education can be reluctant at times. If you're ever advocating for a young person, don't let that deter you because the Ministry is obliged to assist and indeed they must assist. And in fact, it's unlawful if the Ministry doesn't facilitate enrolment of a child under 16 in another school. So persist and speak to the local Ministry of Education representative who's been allocated the case and persist with that insistence that the student needs to be placed in another school. Some of our research has indicated that average time out of school can be up to 50 days, whereas internal policy of the Ministry says it should be no more than 10 days. So if you're advocating for a young person, really push for that 10 days and note the real issues with the student being out of school for such a long time. Where a student is over 16, it's called expulsion. They're removed from school, and I guess the protections that are available for students that are under 16 are much more limited. For instance, once you're over 16, there's no legal requirement you be in school, so there's no issue of truancy prosecution, and schools are in a much more powerful position to say we don't want to accept enrolment of the student. They've legally don't need to be in school, and we don't want to accept enrolment, and the Ministry of Education might be far more reluctant to exercise their discretion under Section 16. But again, what we say is don't let that deter you. If you're supporting a young person, pursue the ministry and ask for their support, because very often if the ministry will support you, the school can be persuaded to accept a young person. So the board, as I said, has a few decisions open to it. It can lift the suspension with reasonable conditions or without conditions. It can extend the suspension with reasonable conditions for a reasonable period. So they might say you're going to stay suspended and we're going to impose these conditions. For instance, you need to complete a drug test and a drug counselling course before you can return, or again, the permanent removal option, which is excluding or expelling. So obviously there's no set guidance around the total amount of what a reasonable condition is or what a reasonable period is. The Ministry of Education guidelines simply provide general guidance that need to be applied in specific circumstances. Because so few cases have proceeded to court challenge, it's actually very hard to point to any precedents which show what a reasonable condition or a reasonable period is. So it just is very fact and specific circumstance dependent. What I would say is if a board's hearing a suspension matter early in the term and they've extended the suspension until the end of the term, that would probably be completely unreasonable. Particularly if the conditions are something which involves something like counselling or drug testing. The student could possibly extend the suspension for a shorter period and then return to school with continued conditions, for instance, to undergo counselling whilst they're at school and continuing with education. It's also important to bear in mind that whilst the student remains out of school, so for instance, if they've got an extended suspension, they are suspended or stood down, there is an obligation on the school to continue to provide the student with academic curricular material to keep up with their education. So if they're just being sent home with little provision for that and they're falling behind or missing their assessments and you're supporting a young person in that situation, it'd be important to point that out to the school as well. So what happens when you don't like the decision the board has made? As I said, it's a pretty strong power that the boards have and very wide discretion under Section 75. Moreover, they don't often all have educational backgrounds or understanding of all the Ministry of Education guidelines in and out. There are very few avenues available to students once they're removed, which is why we've said when you're working with the school, it's better because if once a decision is made, it can effectively be final and can be very hard to undo. So if you can find a way to get on side and work with the school and principal when you're supporting a young person to find the best way forward, and sometimes that can mean just allowing the young person to accept responsibility and putting forward proposals as to what they can do to mitigate what's happened and move forward, because the potential flow-on effects, if they are removed, means it can be much harder for them to get back into school or another school, and there are a lot of other issues that flow from that as well, which we'll talk about in a bit. So at the moment, there are really limited options. One, you can just write to the Board of Trustees and ask them to reconsider their decision. Usually this is helpful if there's new information or a change of circumstances. Not always the case, and you're essentially asking the same board that sat on the first decision to look at their decision again. So not a high chance it's going to be successful unless there's something really compelling in what you present. There's also the ability to complain to the Ombudsman. The Ombudsman has the authority to investigate these decisions. However, essentially the Ombudsman only has the power to look essentially at whether the overall decision was fair. So if the process was carried out in a correct manner, or if the school considered all the relevant circumstances. the other issue with the Ombudsman is that it's very lengthy. There's a significant delay with any complaint. So on average, it can take a couple of months for the Ombudsman to issue an opinion. And the opinion is not a binding opinion. It's only a recommendation, so the school is free to ignore it. The reality is it's probably quite powerful having an opinion come from the Ombudsman, and a school would be highly unlikely to sort of ignore it, but they are entirely free to do so. And during that time, it means that the young person could still be out of school. So if they're out of school for months and months and months, that's essentially going to affect their ongoing education. Another option is if there is some element of discrimination. So, for instance, you've got a student with special educational needs, or there's some other ground of discrimination. You may be able to lodge a complaint in the Human Rights Commission and seek mediation. The school will only attend if they want to, so they can refuse, and the remedies available through the mediation process doesn't necessarily translate into the student being immediately reinstated in school or removal of that exclusion or expulsion from the student's pastoral record. So again, quite limited. The final option which is available is to seek what's called a judicial review in the High Court. So there's no in-between. There's no, you go to some sort of education court before you go to the High Court. So you can seek judicial review on the basis that the school's decision was a public decision, essentially carrying out a public service of education, and judicial review empowers the High Court with the jurisdiction to investigate decisions of public administrative bodies. If you can show that the school's process was incorrect, so they didn't follow natural justice, or they didn't do all the things set out under Section 14 in terms of fair process and how to conduct an investigation and suspension properly, you might be able to get a judicial review and challenge the decision. The problem is it doesn't actually look at the substance of whether or not the student was, legitimately removed, and also it comes at substantial delay with the court process, so it can take up to 18 months in the High Court to get a hearing, and proceedings range in cost from about $30,000 to $50,000 if you're instructed with a private lawyer, and these sort of things are generally quite hard to get legal aid for. So it's really not a viable option for most students, and there is no in-between. So we've sort of consistently advocated for the fact that there should be something in between. There should be some sort of court or tribunal that you can go to that's quick, accessible, affordable, that doesn't mean you end up in the High Court and waiting months and months and months for a decision. A further problem with the judicial review is that the court doesn't necessarily order return of the student to school, and even if they do, they don't really have the ability to enforce or monitor whether the school complies with that in an easy and effective way. So it can mean that the student still remains out of school, and it's not really a practical solution for them. There are massive social consequences for students that are removed from school. They're 3 times more likely to be arrested, 9 times more likely to be summoned to court, 50% more likely to engage in antisocial behaviour, 70% more likely to engage in violent behaviour. There are health, education and welfare costs. Obviously, if they're not obtaining an education, they're not well equipped to go into the workforce. This can result in crime or social welfare dependency. And it's a particular issue in that low decile schools are overrepresented in these particular statistics. Males are overrepresented, and particular ethnic groups are overrepresented. So there's a real question around whether the mechanisms that are being employed are appropriate when perhaps there are other underlying issues which are leading to the discipline and misconduct in schools. Also, whether or not these particular processes and traditional discipline models are actually culturally appropriate for all students, and whether we're actually addressing underlying causes. I mean, obviously, we don't have the scope or time or ability in this webinar to talk about all those issues, and it's probably the basis of a much wider research project. But it's just something to bear in mind, particularly if you're advocating for a young person who's in a low decile school or of a particular ethnic group. Just really being aware of some of the inherent difficulties that might be faced in those circumstances. So how do you challenge the legal process? So this is what really generally happens when the suspension notice is issued. So there's bad behaviour by the student. The principal makes a decision. It's serious enough to suspend. And the principal then, and referring back to the Ministry of Education guidelines on good practice, will then issue notification to the parents that should be in writing, and it should set out how the behaviour meets the threshold of Section 14 and meets all those definitions. The Board of Trustees hearing, again, must be set within 7 days, and 48 hours prior to that, a board report should be delivered up to the student and their family. This will outline essentially the principal's case. So if you think about it kind of like a court case, the principal will set out their evidence and the grounds of why they've chosen to suspend the student, either for gross misconduct or continual disobedience, for example. I refer again, just in case you're supporting a young person, that the school needs to make sure that they provide guidance and counselling if needed, and they've got that obligation to under the Education Act. And through the board process, obviously, the student needs to be given a chance to have their say and put their side of the story before a decision is made. So obviously it would breach due process and natural justice if you weren't even given a chance to put your side of the story before a decision was made. The Board of Trustees, as I said, it generally consists of people in the community. So, for instance, there'll be a staff representative, parent representatives, up to 4 proprietors representatives for integrated schools. There'll be co-opted trustees in some cases, and some Board of Trustees even provide for a student representative, for a student voice on the board. This only occurs in secondary schools and not all. So, your board's going to be quite a variable bunch of people, and there will be quite a few people sourced from the local community as well. As I said, I talked about the significance of that before, because they may not have a lot of in-depth knowledge of the Education Act or indeed their obligations in carrying out a fair hearing. So it may just be a matter of gently pointing it out, obviously not being too aggressive, because as I noted, there's such wide powers under Section 75 and 76 that can effectively render the decision so final for a student that trying to work with the board and the principal is better in the circumstances. So as I said, there are quite a few issues that arise with the current process. There are problems with just stating the law and pointing out legal technicalities, particularly if you're dealing with a group of people that don't really have a lot of in-depth knowledge of this. It's probably more practical to look at the practical issues, how the student's been disaffected and any underlying issues, and what can be done to move forward. You probably do need to provide some sort of acknowledgement that the student has misbehaved. And if you just end up debating legal technicalities or the fact that, the documentation wasn't perfect or the process wasn't exactly perfect, it may lead to a deadlock and sort of negative perceptions from the board. The board probably doesn't want to hear that you're blaming the school. They might be, this might be the route where the principal's already tried, stand downs, cooling down periods or whatever, even if they're not exactly lawful, before they've actually taken the step and they said, look, we can't deal with a student misbehaving anymore. So the Board of Trustees might be the final port and call, so it's really a matter of putting that case forward as to why the board, should consider the continued future of the student at the school and how that can happen. The other issue is that the board's not a court of law, so, similar rules of evidence don't apply. There's no sort of restrictions on how people present evidence or what can be said. So you're dealing with a much more informal process where it's really quite helpful to get on side with the board and the principal if possible. And as I pointed out in one of the earlier slides, there are so few routes of appeal and they're so limited that it can mean effectively the end of the road for a student if you can't keep them in the school. So, how do you advocate for a young person in this situation? Focus on practical suggestions. What can you offer to the board to show that the student really would like to continue at the school and what they can do to ensure that they do? Does that involve counselling? Does that involve a letter of apology? Things like that. Think about if you were the Board of Trustees, what would your concerns be? Let the Board of Trustees know your concerns and how you're on the same page. Focus on the soft spots. When we say that, what are the mitigating factors about the student that mean that it's important that you keep them in school and give them a chance? So maybe they're going through a lot with peer pressure, maybe they're being bullied, maybe their parents are divorcing. Address those concerns and how the student can move forward. As I said, the reasons are once they're removed, they're going to be out of school for quite a long time, even though they shouldn't be, and it can be difficult to appeal. So practically, when you sort of get put in the position where you might need to advocate for a student in this situation, usually what we suggest is meet with the student before the BOT hearing. Find out from them what happened. Do they acknowledge that they misbehaved? You need to also kind of flip it around and look at whether or not the school would view this as quite serious. So, for instance, if you've got a school with school rules that state zero tolerance to drugs, it's going to be pretty serious if the students, taken or consumed some illicit substances at school. You probably also want to find out, has this happened before and how was it dealt with before? So if you're dealing with a student who's been informally punished for substance abuse at school a number of times before, this could be, really their last chance, and you really need to pull forward all the resources and put forward the case to the school in terms of how the student's not going to allow this to happen in future. Special circumstances. So some of those things I mentioned before. Things like, have they been bullied? Are their parents splitting up? Is there peer pressure? Do they have a diagnosed disability or an undiagnosed disability? Is this really out of character for the student as well? And what does the young person want? So obviously, in cases where the young person is not old enough to know, you may be taking some cue from the parents. But however, if the young person is old enough and mature enough to sort of make a decision about their continued schooling future, you might want to see, what do you really want? Are you willing to suggest that you'll go to counselling or otherwise to return to school? Obviously, if the young person is just not at all wanting to return to school, it's going to be pretty hard to present that to the board and ask them to speak to the board about that. Checking with the student if they think that they've crossed the line, and checking what support they have in their life, because this might be an ideal time to bring some support into their life if they don't have any, for instance, with counsellors or otherwise. So with mitigating factors, if they have accepted that they've misbehaved and there's clear evidence of that, if they show remorse and promise improvements, the board's obviously going to be really receptive to that. If they genuinely don't think there was any misbehaviour and your assessment is that's probably the case, you could probably provide an explanation of what happened, but acknowledge, that there was still something that went wrong and seek ways to move forward. Some things that students can do are things like a letter of apology, emphasising good points that they have. You might want to ask the student to approach other people that know them, for instance, teachers, coaches, church group leaders, to provide letters and support and explain special circumstances. So if you've got, for instance, a student who's really going through a lot that the school might not be aware of, making the school aware of that. So moving forward, things like making reparations, agreeing for reasonable conditions. So, I've talked about some of those before, like a daily report or, checking in. It's important that when you do this and you advocate with a young person, you're flexible and creative. So, what can you present to the board that will enable them to think, well, the student can return to school? Make sure that they're conditions which the student can control themselves and comply with. And all plans moving forward should really be wraparound. So that involves, making sure that if there's something that's happening at home, it's going to be rectified, so it's not going to mean that they can't meet the conditions. So, for instance, if it's continual disobedience for continual truancy, but actually the student might have a seriously depressed mother and is not able to get to school on time, these may be things the school is not aware of, and if you make them aware of it and how things are going to be rectified at home, got a much better chance of getting them to return to school. The thing is, to balance law and practicality, you need to assess how serious technical requirements and breaches that the school's made are, because, as I said, it's a final port of call, and there's so much difficulty with overturning or making sure the student gets back into school after a decision that getting alongside the board is great if you can. Emphasis on practical options, apologising and moving forward is probably preferred. Having support of the family and emphasising to the board, those requirements under Section 13, that exclusion and expulsion should be a last resort, and, sort of just gently pointing out to them any illegal behaviour. So I know we've covered a lot of information, but here are your top tips to sort of take away. Having you there, and as I said, this is so helpful if you've got this information and you're supporting a young person. Just having you there for support is probably going to help them get through that really scary Board of Trustees process as well. While you're there, you're also an extra check to make sure that the school is honest and their processes are fair. And if you can work with the school and find reasonable solutions moving forward, that's going to be the better for the student in the long run, because they're going to have an ongoing relationship with the school in obtaining their education. Hopefully that gives you a nice sort of overview in terms of if you ever are placed in the position of having to advocate for a young person at a BOT meeting, you've got an idea of where to start. Some practical tips in terms of, if once you get the board report from the board, you just want to kind of look at whether the allegation meets the seriousness required under Section 14, and also look at the record of the investigation and if the process was fair. So, hearsay evidence, or if no other people were interviewed to get a full process picture, those are things you might want to challenge with the board on a gentle basis. Hopefully that's been helpful. Again, you'll remember from our last webinars, if you do have further questions, you can always contact us or visit our website, and we also have an app to download. Just a bit of housekeeping again, if anyone's joined and there are multiple people watching off one computer, we'd really appreciate if you can type in your name separately so we can keep a record of our attendees. Also, we're going to distribute a survey following the webinar, just asking you to evaluate whether you found the information helpful, which is helpful for us in our reporting requirements. I'm going to keep the chat box open for any questions that people might have for just a minute or two. And if there are, I'll try and answer them verbally. If you think of anything in the future, feel free to contact us via email. And thank you very much for attending our webinar. I really hope that you found it useful and that you can attend our following webinars in the future. Thank you very much.